Good morning or good afternoon, evening to everyone. My name is Andrea, Chmielinski, and I have the pleasure of coordinating PrivacyRules. PrivacyRules is a global worldwide alliance of privacy, data protection, and cybersecurity experts present already in 50 jurisdictions and growing. Our scope is the one of disseminating accurate information, independent information, professional information on privacy, data protection, and cybersecurity, and above all, being the condition to offer to companies and institutions in any country accurate, top-notch advice on these topics. Privacy is obviously one of the main concerns also in COVID-19 times. We have already published webinars where we have been discussing with our experts about tracing gaps, among others, and other topics that are closely connected between the spread of the pandemic and privacy of individuals. Today, we are discussing with non-European and non-American experts the consequences of the Schrems II case, the decision adopted by the Court of Justice of the European Union in regards to the transfer of data of EU citizens, not only in the US, but in the other parts of the world. There is no doubt that the decision adopted by the court, which invalidates the privacy shield, so the legal framework that was allowing the transfer of data from Europe to the US, it's groundbreaking and has the potential of changing definitely how the European Union will see the adequacy of other legal frameworks in other parts of the world. We are discussing this with an excellent panel of experts. I will name first Dotan, who's an expert from Israel, who will be also the moderator of this panel. Israel is one of the jurisdictions having an adequacy decision adopted by the European Union, so his perspective is particularly important, and not only, of course, because of his great expertise. We have together with us also Stephen Mathias from India, working for the law firm Kochhar, one of the main law firms in India. And actually, Stephen is one of the most prominent experts on data protection in India. He has a long load of relevant international publications on the topic. We have with us also Pádraig Walsh from Turner David, a law firm in Hong Kong, which is very important because, as we know, that is a jurisdiction where a lot of data is trafficked towards Asia. And finally, we have also Akira Matsuda from Japan, another jurisdiction that was granted the adequacy decision from the European Union. Akira is an expert on privacy, of course, and is a partner in the law firm Iwata Godo. I want to thank also my colleague Alessandro Mattia, who is with us always in all our publications and is definitely the master of puppets of PrivacyRules. So thank you very much, Alessandro, for being there. Also because Alessandro will help us in the moderation phase. So for all of you in the attendance, I invite you to use even the Q&A button in order to send questions. We can receive them already starting from now, and we will present them in the very last part of this webinar. So I don't want to take much time anymore. I thank all the panelists. I just want to conclude with the recommendation to everyone in times of pandemic, of course, to follow the advice of the authorities and to protect yourselves and the colleagues and families you have near to you. Thank you very much, Dotan, for accepting moderating this very interesting webinar. So the words goes to you. Thank you.
Thank you. My name is Dotan. I'm a partner at Peral Cohen, a prominent Israeli law firm with international presence. And we counsel a wide array of clients, both from technology-driven companies to brick-and-mortar companies, all around the ins and outs of data protection and cybersecurity and privacy in Israel, mostly in the EU and in the US. Now, as we probably all know, a few weeks ago, the Court of Justice in the EU invalidated the Privacy Shield, program for personal data transfers from the EU to the US. That's the Schrems II case, and within the same judgment, the court also basically upheld the standard contractual clauses, which is another mechanism for cross-border data transfers, although it did that with certain conditions, which might be problematic, as we'll probably hear throughout this, this webinar. Now, the court's decision in validating the Privacy Shield explains that the US laws allowing security and intelligence agencies in the US to access on a mass and indiscriminate scale to access personal data of individuals, of data subjects, of EU data subjects particularly, these types of legislations were found to be interfering with the fundamental rights of individuals in the EU in a way that basically the court found to be inadequate and not up to par with the standards within the EU. And basically this was determined to be a disproportionate type of access that goes beyond what is strictly necessary in a democratic society. And interestingly, Israel, as Andrea mentioned, has been recognized as an adequate jurisdiction since 2011. And some of you may know that within the GDPR, the EU Commission is actually required to periodically reassess its adequacy decisions. And what we know is that around 2019, the EU Commission actually began reevaluating Israel's adequacy status. And what we also know is that recently, specifically in Israel, there were public disclosures on the news of types of mass scale monitoring conducted by the Israeli Security Agency. This was sort of a revelation that made it to the news, where with the support of Israeli legislation, specifically the legislation establishing the Israeli Security Agency, as well as the communication law, both of these laws support the broad access given to the Israeli Security Agency to telecom data. And the concern is that, somewhat like the invalidation of the Privacy Shield for the US, given the broad and indiscriminate access that US security agencies have to this type of data, the concern is that Israel might follow, or basically the EU Commission would follow the same footsteps, and there's a genuine fear that Israel's adequacy decision is at risk. At this point, no decision has been made to date from the EU Commission, but that is certainly the fear. So that's the Israeli perspective initially, and I want to ask Stephen. We know that India is a large outsourcing and offshore industry, and I'm wondering, for the benefit of our knowledge, what do you see in terms of the judgment impacting the flows of EU data to India?
Hi, good morning and good afternoon to everyone. Yeah, I think, India has the largest outsourcing and offshore industry in the world. And while the US remains the biggest customer for these operations, there are significant EU headquartered multinationals who also outsource or offshore to India, and the facilities are extremely large in India, and undoubtedly there is access to personal data of EU citizens. Now, as you mentioned, the flow of data is mostly going through the SEC route. That is the standard contractual clauses. And up till now, we've believed that doing it that way is adequate. India doesn't have a comprehensive privacy law. And so the question of getting an adequacy ruling has never arisen. We do have a draft law that's currently being debated by a joint committee in Parliament. And that might get the force of law possibly by the end of the year. So I think the issue here is that if the EU concludes that the rights of EU citizens are not fully protected with regard to access to personal data of EU citizens by the US authorities and not by private organizations, then you have to look at the same type of access by the Indian authorities. So currently, there are a couple of provisions that allow for access to any kind of data, IT systems, and so on, interception, and so on. And that's available to Indian government security agencies. The specific grounds mentioned under the Constitution, and those grounds are followed in the IT Act when dealing with any kind of, should I say, invasion of privacy. So the question really here is, what is it that the EU considers as a standard that's acceptable? The EU may state that there are certain redressal mechanisms that's not available to EU citizens in the US. What is it that they want as a minimum standard for India? Because the Indian law is a little vague when it comes to what kind of court remedy you have if your personal data has been accessed, you feel it's unjustified, and so on. Most likely you have an option to go to the High Court and Supreme Court on a writ petition. But Indian courts tend to be fairly conservative when it comes to security issues. They tend to defer to the government on that. So whether India has adequate redressal mechanisms in place or not is not absolutely clear at this point. Probably requires more guidance from the EU itself. If I were forced to, give an answer, I would say most likely it's not adequate based on what I've seen in the judgment. So that has a concern then for all of these offshore operations in terms of what they do now, and certainly the government and the EU and other stakeholders need to come up with some way to deal with this judgment.
Yeah, that's certainly something I think we all relate to across all countries. Pádraig, I'm wondering about the data access laws in your jurisdiction. How do you see those laws in the context of the EU Court's judgment on data access by public authorities? How do you see that play out in your jurisdiction?
Well, we've had a fairly interesting 6 weeks in the data protection world here in Hong Kong, because on the 1st of July, we had our national security law introduced, and implementing regulations for that about 8 days later, and about 10 days after that, the Schrems II judgment. So there's been quite a lot going on. So the issue of whether the laws in Hong Kong around national security and whether public authorities and government bodies have access to EU data in Hong Kong, that's only been an issue that's really been, we could look at for all of maybe 30 days at the moment. So it's all brand spanking new and still a bit uncertain, because the way it is, or the way that I look at laws, is that there's the laws as written, but they really gain meaning and credence, particularly in common law jurisdictions, in terms of how they're enforced and applied in the courts. And the jurisprudence of that then gives rise to a body of knowledge where you can make judgments and assessments about things. And we're, in Hong Kong, we're just not there yet in terms of being able to make those kinds of assessments. But if you were to look at the national security law as written, and you were maybe to compare it to the issues that arose in respect of the, at least how the ECJ interpreted equivalent or similar issues in the US security rights and intelligence gathering rights. The national security law in Hong Kong does not have all of the same features. For instance, you wouldn't describe it as a mass surveillance law. It isn't something where the authorities can indiscriminately target a broad number of people and gather their data. It's more in the nature, there is a process that's involved where the senior police officer needs to make an application that is then signed off by an even more senior police officer with prescribed information, and that goes to the chief executive to sign off. So there's process in there. And it's something that needs to be in relation to an investigation of a specific event towards targeted individuals. So there's proportionality in terms of how the surveillance rights are going to be invoked and implemented. This is something that is different. Things that are maybe a little bit similar to the position in the US is that the decisions that are made are not subject to judicial review, and you can't necessarily point to individual rights of access to the courts to review the decisions and so forth. But this is one of the anomalies I find with the Schrems II judgment in any event, is that a lot of the kinds of investigative activities that are undertaken for national security reasons are covert in nature. So if they're covert, how can you have rights of access to the courts? You know, the person's not supposed to know about it. If they do know about it, something's gone wrong. So there is that kind of an anomaly in terms of how, which makes me think that if you look at the different factors that are involved, not all of them should have, or may indeed be interpreted to have, the same weight to them. But that's one of the quandaries that lies ahead. So in brief, in Hong Kong, you might say it's a slightly mixed report card, but you would say that on the elements of proportionality, we're in a better position. But it's all brand spanking new. So, you know, we need to wait and see how these laws are actually implemented in practice.
Yep, that's true. It's a key point that you mentioned with the anomalies. Akira, you're also in a non-EU jurisdiction, a third country, what is called under the GDPR, and I'm wondering how you view the Schrems decision impacting your jurisdiction, especially with the fact that rather recently Japan was recognized as an adequate jurisdiction by the EU Commission.
Thank you, Dotan. I would like to touch on two examples where this Schrems II decision is relevant for companies headquartered in non-US countries. Then I would briefly explain the impact in Japan. The first example on the relevance is that where the company has a US subsidiary of affiliates. In this case, if the EU personal data owned by transferred to such US subsidiary or affiliate, transfer of EU personal data to US would occur. The second example is where a controller located in a non-US third countries uses tech or marketing assistance application or services that are provided by US companies. For example, if a global company headquartered in Japan owns EU personal data and such data is put in the marketing assistance tool provided by US companies, there is a transfer of EU personal data to the US. In this case, it should be noted that even if a company group has no physical existence in the US, transfer of the EU personal data to US may occur. As Dotan mentioned, Japan is an adequate jurisdiction and EU personal data may be transferred from EU to Japan without additional safeguard measures. However, if such EU personal data imported to Japan based on adequacy decision and subsequently transferred to non-EU third countries, such transfer must comply with Japanese cross-border transfer requirement. Such requirement include consent of the data subject or safeguard measures to ensure equivalent protection, such as data transfer agreement or binding corporate rules, which are similar to SCC or BCR under the GDPR. Under the current Japanese framework, whether the level of protection required under data transfer agreement or internal corporate rule is met in the importer jurisdiction is not strictly tested. However, after Schrems II, importer country analysis may be even required from Japanese law perspectives, especially when EU personal data is included in the transfer. There is an amendment ongoing in Japan, and I believe the Schrems II decision will be taken into consideration for discussions for such amendment, but I will touch on this topic later on.
Okay. So all of us were basically in the post-earthquake phase of Schrems II. And I can can provide some more commentary on how Israel has been responding to to this development. So interestingly, Israel's privacy law dates back to 1981. And unfortunately, it's really painfully old and outdated, and it was seldom amended. In fact, the last amendment to the privacy statute was in 2012, 8 years ago. And yet, just 1 week after the Schrems II case was published and issued, the Israeli government all of a sudden hastily scrambled to issue a draft bill to overhaul, or rather to amend, the outdated privacy law. It's been issued for public comment, as a draft bill usually is issued in Israel. And if you ask me, I do not believe in coincidence. It probably isn't a coincidence that this is just 1 week after the Schrems II case. It's very likely that the Israeli government fully understands the consequences of a rescission of Israel's adequacy decision. If that were to occur, that would really impact thousands of Israeli organizations that process personal data originating from the EU. And today they do it seamlessly. And with an EU adequacy decision rescinded, they wouldn't be able to do it as easily. What is interesting about the draft bill that's been issued is that it tries to take the 1981 bill to today's modernity, in the sense that it really tries to follow some of the footsteps of the GDPR. So for instance, it proposes to amend a few of the definitions so that they would be much more akin to the GDPR's definition. For instance, the definitions for a controller and a processor would become much closer to what the GDPR defines these concepts to be. It would also expand the definition for processing. Today's definition in Israeli law is very limited, and the proposed amendment would really follow the blueprint of the GDPR in what processing would be defined. And I could also give the final example is that in the explanatory notes that followed the draft bill, it was clearly indicated, the government clearly indicated, that it actually plans to follow with 2 subsequent draft bills that would generally overhaul the 1981 privacy bill in Israel. And they've actually stated it very explicitly that they would like to modernize the legal bases that are available for processing. For instance, in today's law in Israel, you may only process data on the basis of consent or legal obligation. And the government's explanatory notes indicates that they are looking to expand these legal bases. They also want to cover and provide much broader data subject rights than are in today's outdated law, which only provides for the right of access and some kind of limited right to rectify and delete. And finally, they also mentioned that they would like to elevate the standard of accountability imposed on processors and controllers. So we can already see that Israel is trying to make up for sort of lost time over the past 3 decades and trying to overhaul the bill, maybe in an effort to try to prevent the repeal, the adequacy decision of Israel being repealed. That is what we are sort of seeing over the past few weeks right after the Schrems II decision. And I know, Stephen, I know that worldwide there have been various consequences on this specific topic. Do you think India would need to change and overhaul its privacy legislation that you mentioned isn't, at this point, isn't exactly a comprehensive type of legislation? And how do you see that process transpiring, if at all?
First of all, I'd like to say I'm quite impressed by the Israelis in moving so quickly. The authorities in India have barely woken up to the realities of this judgment. So we have a personal data protection bill that was prepared more than a year back. It was introduced in Parliament in December last year, and then sent to a joint committee to review it further. And that committee started, it had a few meetings, and then from March onwards till very recently, there have been no meetings for obvious reasons. So they've continuing their work now on that bill, and I expect we'll have possibly a close to final draft that will then be sent back to Parliament and would then be reviewed and approved by Parliament. So this draft law basically gives the central government the power to not apply. Hello? Yeah. To not apply any of the provisions of the privacy law to specified government authorities. And this is a very sweeping provision that gives them unlimited discretion. So obviously there's a lot of concern over that. So I think this Schrems II decision is less about privacy norms of a country and more about the unbridled investigative powers of government agencies. Nevertheless, the other aspect is that there is a provision in the bill which allows the government to exempt any provisions of the bill relating to data processors of foreign personal data, that is of persons from outside India. And this is meant to deal with the offshore outsourcing industry. But this is not a blanket provision that applies automatically. The government will have to issue a notification specifying in what way will the law apply or not apply to the foreign data. So I think government has to probably move very quickly here to determine what they have to do, either under existing law or under this personal data protection bill. I guess one way to deal with it is to have specific provisions relating to foreign data, but that might lead to a lot of angst where people might feel that foreign data is more protected in India than data of Indian citizens. So we'll have to see how that goes, but clearly it's an issue that needs to be dealt with in this bill.
Okay.
I wanted to mention one thing which has already been talked about, which is that I feel the judgment is not absolutely clear in terms of what kind of redressal is a minimum standard in other countries. They've concluded that the US doesn't meet that standard, but what is the standard that they want? And one has to look also at what is the standard in the EU. And as rightly pointed out, these kind of investigations are covert. So how does a person even get to know that his personal data is being accessed or being investigated? So I think there's some ambiguity there which the EU authorities need to probably clarify before other countries start moving forward in dealing with this development.
Yeah, I've come across criticism basically looking at the Schrems II judgment and asking whether the EU institutions themselves, the EU member states, do they not operate in a way very similar to the way that the US authorities, security agencies operate? That's a question that I'm not sure we all have the answer to, but it's something that has come up and is worth considering. To what extent is the EU asking of the US and other countries requirements that maybe the EU member states themselves do not live up to?
Right. I mean, I think you've got to differentiate, right? You've got to be able to say that this is what we have, this is what you have. What you have is not comparable to what we have. And once you set that standard, then other countries will say, okay, this is the standard that we need to meet.
Yeah. So taking this sort of zooming out into a more global perspective, Akira, what do you think are the more sort of long-term and short-term implications on companies or organizations acting as data importers for EU data when they are located outside the EU? What do you think these implications could be?
So I will start from the short-term impact. In a very short term, these importers must assess and map the data transfer of EU personal data, then classify the EU data export without adequacy decision into two categories. First, EU personal data export to US based on US privacy issues must be switched to SCC arrangement as a first option. Second category is that the EU personal data export to other countries based on SCC must be analyzed in detail, specifically on whether the level of protection required under the SCC can be respected by the data importer or whether additional safeguard measure is required. Such analysis should be on a case-by-case basis, and the key factors should be what type of data is transferred and what is the risk of governmental access by the government and the surveillance. In Japan, Schrems II decision would impact the triennial amendment discussion. The amendment bill on the data protection law has just passed the Congress of Japan in June. Currently, drafting of sub-legislation and the guidelines are in process. Schrems II decision may impact such drafting as it requires in-depth analysis of the third country's legal regime in the case of EU. Japan may introduce the similar framework to keep the adequacy decision on board. And moving on to the long-term impact, I believe that the transfer of pseudonymized, anonymized, or encrypted personal data as an additional safeguard measure would be more prevalent, as this may avoid the data being accessed by the governmental authority for national security purposes. Furthermore, global harmonization data protection regime may occur. This is because some similarity to GDPR regime would be required for the EU data to be imported into such jurisdiction.
So you bring up the critical point of the standard contractual clause as an alternative. And that was really one of the key issues in the court's decision, alongside, of course, the invalidation of the privacy shield. And Pádraig, I'm wondering, what do you believe or recommend to use as some of the alternatives to the standard contractual clauses for those data importers that are established outside the EU? What types of alternatives are there?
Well, I guess you could describe them as alternatives that are already described within the relevant chapter of GDPR relating to international data transfers, and then other supplementary measures that you could think about adopting. So if you go through the different alternatives that are framed within the chapter on international data transfer, you start with adequacy, which is something that is done at an EU Commission level, and is a long process, and is a process that is really state to state. So it's not something that a business can actually do. If you look at standard contractual clauses and you're looking to rely upon that as an appropriate safeguard in order to have equivalence to EU levels protection for personal data, then in addition to just signing off on the contract and implementing that contract, now you can see a situation where there'll need to be impact assessments in respect of the other means of access to EU data that the data importer may be exposed to, according to national security laws and so forth. So that is one alternative. One alternative is to continue to use or to switch to standard contractual clauses, but to combine that with an assessment of the legal framework in your jurisdiction, and to see or try and come up with some assessment of whether that achieves EU standards of protection. You could imagine, and there will be frameworks that will be published by data protection authorities in the EU, and there'll be some assistance in respect of how you can implement and go through those frameworks in the countries of the data importers. Outside of that, another appropriate safeguard is binding corporate rules. And I think the difference between standard contractual clauses and binding corporate rules is that if you're going the BCR route, it's a longer route. It's something that requires sign-off and approval by data protection authorities within the EU, and then is applied across the organization as being the framework that applies globally in respect of data protection. So invariably, that's not a quick fix. That's not a short-term solution. But I could see a path where more organizations that are global in nature will think about BCRs and will be encouraged to go that route, because if you do have the sign-off of data protection authorities in the EU as part of that process, then it's more likely to be sustainable and supportable in the medium to long term, because these kinds of issues no doubt would be assessed in the course of going through that particular, process. But that's a medium to long term approach. In terms of other derogations within the GDPR chapters, you've got derogations relating to consent, derogations relating to particular, a legitimate, vitally legitimate interest. But if you look at these, for instance, consent has to be express, specific, and you need to obtain the consent in a simple, straightforward way. And probably most importantly, in terms of data processing arrangements, consent can be withdrawn. So it's not hugely attractive in terms of a solution, because you're dealing with almost a data subject by data subject basis, which is not really how business is conducted. And if you look at specifically legitimate interests of the business and so forth, that's intended to be a rare exception, not something that you conduct the whole business operation on. So I think ultimately it will either come down to the non-GDPR type fixes are things about proportionality and data minimization, anonymization, these kinds of techniques, on the basis that if it's not in the hands of the data importer, or if it's not personal data because it's been anonymized, therefore the concerns disappear and you can continue to do what you're doing. But even with those, it's not necessarily going to, you're asking people to change behaviors, and there'll be certain types of processing activities that can't be done on an anonymized basis. So it's not necessarily a solution for all. So it's quite a complex situation. But what has become clear, both from the ruling of the ECJ and from the subsequent FAQs published by the European Data Protection Board, is that if you don't find a solution, there are two things you can't do. You can't do nothing, and you shouldn't necessarily do everything, in the sense that doing nothing means that you're definitely just ostrich mentality, and you're probably going to be found at fault. If you do everything, as in stop all data flows, well, that's going to have a serious and profound impact to your business. So I think what you'll find in practice is that businesses will take a moderated approach to things, and if they're using if they're relying on a privacy shield or equivalent, they'll move to standard contractual clauses, much as Google did this week, which made me smile with a wry smile. So you'll find that they'll move to standard contractual clauses. But I think what they'll do is that they'll start going through contracts and their arrangements on a case-by-case basis, dealing with the more significant and impactful contracts first, and then moving from there to see where they get to in terms of their assessments. So that's what I see as being the solutions in terms of the business approach.
That's very complicated for companies to consider, I think, which is one of the implications of the Schrems II case. And if we think about this conceptually, it's quite possible that some other type of business alternative would steer processing toward data localization, perhaps, while another alternative conceptually could be countries around the world, and maybe this is what Israel is trying now to kickstart, is to elevate its laws to become more close to the EU standard. And I'm wondering, Stephen, how do you see this impact? Which of these do you think will happen first in terms of what will be happening on the ground? Will will countries first be able to sort of migrate and mobilize, so to speak, their laws to an elevated EU standard, or do you think that countries would companies actually would alternatively first choose to take the localized data approach?
Yeah, I would continue with what was just said, which is it really depends on what route you're using, and what works for you best, and also which country you're in, and what the laws of that country say. But there's a possibility that no matter what route you go under, this issue will still remain, because this is not an issue between two private organizations. It's an issue concerning government agencies. So there are essentially two options. One is data localization, and the other is to change a country's laws and bring them in line with the EU. Bringing them in line with the EU, as perhaps Israel is looking at now, is definitely possible, but it's a long drawn effort. There are issues surrounding sovereignty and so on. And I think there also needs to be clearer direction from the EU as to what exactly it wants. Data localization is probably workable for some companies. So when I think of a Facebook which is involved in this particular case, my thinking is, just move all the EU data on Facebook to Ireland. And when you're doing updates, send those updates to Ireland and then do the updation in Ireland. So something like that could work. We're facing a similar situation here where the Indian government has banned a large number of Chinese origin mobile apps. And we have several of these Chinese companies come to us and ask us what's the way forward here. And of course, there's a process going on. There's a questionnaire that's been sent. They're sending their replies and all of that. But essentially what we're telling them is move your data to India and build a mechanism where all the updation is done in India, and you're able to satisfy the authorities that there's no movement of data out of India at all. And if you do that, then you you stand a chance of getting over this. I know there's a political overtone to all of it, but the law is a law, and you still have to, government still has to satisfy that there is a security implication where data is located in India, processed in India. Then it becomes harder to take that view. So I think really depends on company to company, country to country, what the data is, what the route they want to use.
So I know one angle we haven't yet discussed is data protection authorities in third countries. And I'm wondering what type of support or guidance can these types of data protection authorities outside the EU, what kind of support can they provide companies that are dealing with this rather chaotic situation right now? Pádraig, what do you think these authorities can actually help, if at all?
If at all, yes. If you look at the context in terms of how this becomes relevant, what the European Court of Justice has said is that this is an issue where the primary obligation rests on the data exporter, but that there are also obligations that rest upon the data importer. Basically, the contracting parties are the primary parties that have to sort it out. Now, if you're speaking about commercial parties in business, they're not really equipped to make the kinds of judgments that the European Court of Justice is asking them to make. But also, if you look at the dynamics of that relationship, EU data exporter, third country data importer, well, the EU data exporter is not going to know the laws of the third country where the data is being exported to. So, for instance, a data exporter from Ireland, even though I'm Irish, so okay, will not necessarily know what the personal data protection laws or the national security laws are in Hong Kong. So what are they going to do in their contract? They're going to shift the emphasis to the data importer. So pre-contract, there'll be some assessment or diligence that you need to go through, where the responses coming from the data importer are going to be responses around issues like national security driven access to personal data that's being exported. Something that the data importer will have to grapple with. And then in the contract, there may be undertakings, reps, warranties, these kinds of provisions that will say that, either you will not provide that kind of access, which of course would be unlawful, that puts the data importer between a rock and a hard place, or that you'll give some kind of notice if it occurs, which of course, under most laws, if you have that kind of an access request, A, you may not know about it, and B, if you do know about it, you're almost guaranteed to be told not to tell anybody about it anyway. So again, you have the same issue, that you either breach your contract or you breach the law. And this is the quandary that the data importer is going to find himself in, and it will flow in that direction. So if you look at what data protection authorities in general need to do to be able to support that, within the EU, what I expect is that the various data protection authorities will come out with frameworks, will come out with standard questionnaires, these kinds of things, which data exporters can then use, pass them on to data importers. Now, if you look at the data protection authorities in the third countries, those authorities, well, they're not exactly going to lobby for changes in national security laws. That's one thing I bet my house on that. But what they will need to do in some way is to provide some guidance note to data importers in terms of how they would go about responding to those kinds of questionnaires. Not necessarily to give standard or model answers, because they're not in a position to do that. And within that, there is a role for lawyers, because ultimately some of these questions are going to be questions about published laws in those jurisdictions. And that will probably form part of the guidance of the data protection authorities in third countries, that some questions you need to go to your lawyers for. These are, and some ways of do's and don'ts in respect of what they can't agree to or shouldn't agree to, and certain things and a certain process to follow to find themselves, to pick their ways through it. But the cost of compliance just got a lot higher.
Yeah. So you illustrate, Pádraig, the complexity of assessments that will be sort of shifted to the doorsteps of both the data importers and the data exporters. And it will certainly become complex, particularly for those companies who do not really have access to interconnected privacy advice like the privacy rule members can offer. And I'm wondering, Akira, how do you think these types of non-EU data importers, how could they, practically speaking, go about conducting these assessments, that the assessments of the security laws in their jurisdiction, as seems to be required now by the Schrems II decision?
Yes, as being discussed, in case EU personal data is imported or exported, these importers should need a case-by-case analysis to comply with the GDPR, and even from my perspective, Japanese law after Schrems II. Therefore, I strongly believe member firms of the privacy rules may provide such case-by-case analysis on a global level and very efficiently to assist the clients.
I think all of us in Privacy Rules, the members of Privacy Rules, we really want to provide actionable and clear privacy advice and practical guidance. So I'd like to provide my sort of take on this, and basically taking bits and pieces from the great advice that we've heard here today. So I think first and foremost, we strongly recommend to map out your data flows and understand the nature and the specifics of your flows, because without understanding this, what is basically happening within your organization, you can't take any steps forward. And I think I can certainly say from my advice and from my experience is that you'd be surprised to understand how many nuances you're bound to find if you go through this fact-finding process. Things that you haven't known are happening within your organization, things that are outdated and should be long eliminated. So the fact-finding phase is critical in our mind. I think another recommendation would be to look at ways to try to minimize international data transfers. And again, if you look at your data inventory, you could easily, or you could likely find that you have data flows that are not really necessary, that are no longer really appropriate for your business, and you can eliminate them. And of course, data flows that are eliminated are one less a problem to worry about. Obviously, we've talked about exploring other alternatives like using the standard contract clauses, and it was also a measure that would be appropriate to look at data localization options. This could be localizing data within the EU jurisdictions, for instance. So this would be probably a timely opportunity to look at the ability to leverage service providers that operate within the EU and be able to leverage their services and their processing activities as a way, again, to minimize data flows outside the EU. And I think above all, it's important to keep track and keep appraised of developments at the regulatory level. We know that the European Data Protection Board has issued its first set of Q&As a few days after the Schrems II case. And within those Q&As, it actually indicated that it plans to follow up with more practical and specific advice on what specific measures data importers and exporters should take within their assessment plan. And so monitoring these developments is important, and certainly the members of PrivacyRules can help companies achieve that because that is basically our business and what we are here to do.
Dotan, if I can take over from here. First of all, thank you very much for moderating this great panel, and of course, thanks to all of you participating here and sharing your knowledge. As a matter of fact, actually, we invited also the Data Protection Board, the European Data Protection Board, to take part in this webinar. As you can imagine, they are overloaded by requests of the same kind, and just a couple of days ago, they kindly declined because they were busy elsewhere. But they said that they would be happy to participate in a possible new event with a little bit more of time ahead before we go live. So we will try to do that. PrivacyRules continues publishing information in regards to the topic that we have discussed. As a matter of fact, this is the second webinar we have. We had already one webinar on the decision on the 21st of July, and it's already published on our platform. So we invite everyone in the audience to visit our website on the webinars and podcasts section and to find how the decision was debated by our EU and US members. So to have the perspective of those right at the center of the Privacy Shield invalidation. But all of you clearly elaborated and represented the fact that this decision has an impact everywhere. And it's a step back to what we thought was going to become a sort of international framework and regulate data transfer more on a regular standardized base. Now, we need everyone, any company in the audience, any company worldwide needs local advice, because the local advice is complex. It's an interpretation of surveillance laws, it's an interpretation of constitutional rights, of privacy laws when they are present, or otherwise, like in the case of India, when they are not present, regulations and otherwise data protection authorities, guidance, and so on and so forth. So it's a tapestry of different bits and pieces that needs to be interpreted every time. We have three questions, so I don't want to take much of your time right now. I think, Alessandro, maybe you can submit the questions, I believe, for some, if not all, of our panelists.
Happy to. Thank you, Andrea. And yes, there is a third one that we received privately, and I would like to start with that one since it's pretty practical. And the question is the following, is I think pretty broad, so any of the speakers of today can answer to that, is how can you understand how reliable are service providers such as ones for data storage? For example, Amazon is complying with the EU regulatory changes. What would you check to ensure that similar companies are compliant other than just trusted? Don't know if anyone would like to take the lead on it.
I can at least start maybe, Alessandro. If you, I mean, I think what you do in any situation, whether it's a data transfer or for whether it's for data processing activities, is you start as on the basis that it is a diligence exercise you must do before you initiate the contract. So some of that starts on your own side because you assess what data it is you are looking to transport or to have stored there. And then some of it is done through you know, questionnaires and basically interaction with the service provider you're looking to use. Now, some of the way you make your judgment, there's some of it is practical and some of it is based on the actual content. The practical part that I would see is that if you're dealing with an organization that has experience and track record, they will have the responses almost in a pre-packaged delivery for you. So you send in your questionnaire, they've got all the information ready, and it comes back to you within, you know, a couple of days, you know, whenever it comes to the top of that person's email inbox. For organizations that or maybe don't have that track record, what you might find is that it's a bit of a scramble in terms of them getting that information to you. And the information when it comes may not be what you're expecting it to be. So that's one of the tell signs. But and then you look at the content of the answers. If the answers are coherent, if they show that there's proper internal controls, there are proper officers, there's a proper management program in respect of how information and data security is handled, and they have appropriate certifications and appropriate review and training mechanisms, these kinds of things, then you're getting to a stage where you've got certain levels of reassurance, and you can move on to looking at maybe the contracting documentation. Now, if the documentation, the contract documentation, stacks up with them taking responsibility in respect of information security, as opposed to saying, you know, I'm responsible for nothing. You know, you send your stuff to me and take your chances. You know, if you see provisions like that, you might be concerned about it. But if you see provisions which are more balanced, saying, you know, these are the things that we do, these are the services we provide. If you provide things in the way that we can actually service and handle, then we will stand by our services and be responsible for that, and will be liable if something goes wrong. If the contract is along those lines, then that's another reassuring part. And then you look at things like, you know, look at your peers. Who are they using for similar services? Maybe speak to some of your peers. Speak in the industry to people who look at the technical side of security. There are a number of technical members and technical experts within PrivacyRules also. So take up references. These are the kinds of things that can get you to the point where you say, yes, this is an organization that I believe I can trust.
Okay, perfect. Thank you very much. Pádraig, I think we can directly move to at least another question before to end up the discussion, because we have 3 more questions. There is another one that is pretty general and is asked to all the panelists and says, do the panelists see a scenario where the European institutions might block transfer of data of the EU citizens to countries where we have something like the Patriot Act in the US? Pending their assessment of the privacy and surveillance framework in the targeted country? If the answer is yes, is there a risk of political use of that?
I can maybe provide my thoughts on that. Well, we know that the GDPR actually gives the EU Commission the ability, for instance, when it comes to adequacy decisions, to actually suspend an adequacy decision. And with that, that could implicate the suspension of data flows, at least through that track. I find it more difficult to see or to foresee a situation where transfers will be blocked to a given destination altogether. I think that would have significant political implications, and I think EU institutions would fear taking that step. And I think if we look at what the Irish Data Protection Commission has done, again, in my mind, it basically attempted to shift over the burden of deciding to invalidate the Privacy Shield over to the Court of Justice in the EU, rather than determine that itself, even though it could have. And I think, therefore, this really is an illustration of how the political impact of a decision to block data access could be significant, and I think the various EU institutions would be concerned taking that step. So I think it's less likely that we see that, but again, it's purely speculative.
Okay, any other thoughts on this question?
I suggest to take really a couple of minutes more of the time of everyone, if everyone agrees, because there are 2 questions more, and I would like to try to give answers to them as well.
The question arrived while Pádraig was speaking, and it was saying that the point of Hong Kong expert is very interesting. And then it's asked, if an investigation is covered, the subject to the investigation should not have a say. Do you see a scenario where organized criminals will start sending requests to access data to investigative authorities left and right, simply to know if they are subject to investigation and surveillance?
I think anyone can send requests anywhere, but the anticipation that you might get any response apart from silence would be optimistic.
Yeah, I doubt if that's going to happen in most countries. The point on covert, I think what might happen is where a government agency goes to a particular company and says, we want to access this particular data, and the company is uncomfortable doing that. Then the company may approach a court and ask for some redressal, particularly pointing out that we have data of EU citizens and we can't give it because it violates EU law. So I think that's the scenario where you might see actual litigation.
Thank you. Thank you very much also for taking up these kind of hot questions, Stephen. I think we have abused of the time of all of you, but also of those in the audience. We arrived late and we are closing even much later. I take the responsibility and the blame for this. I'm half Italian, and maybe it's not strange for my culture. But we like to engage and to stay with good friends, as all of you certainly in the panel are. I definitely want to thank sincerely Dotan, Pádraig, Akira, and Stephen for sharing your views on this evolving situation, I would say. Unfortunately, because of pandemic times, we are used to these, but definitely the world of privacy is changing, especially because the activity of all of us, private life and business, are migrating more and more on digital. So receiving your perspective from different sides of the world is particularly important. I take just the chance to mention that, for instance, Dotan colleague Haim participated in another webinar we recently had on tracing applications, sharing the peculiar view from Israel in these, which again, it might be part of the topics to be analyzed in the context of the invalidation of the privacy shield. Pádraig is not only the chair of the Know-how and Training Committee of Privacy Rules, and I thank very much him for this, but recently opened the podcast, the Tech Talk. So I invite everyone in the audience interested in learning what happens in Hong Kong, or with part of the focus in Hong Kong, to follow the podcast of Pádraig. And actually, this webinar will be also rebounded there. So we are very pleased. For that. If I'm not mistaken, Stephen is going to publish an article on how the legislation is evolving in India. So definitely also remembering to follow Stephen, who publishes a lot. It's very important, and likewise for what concerns Akira, because Akira has a very long list of publications. I have no idea where he finds the time to do that. Evidently, he managed to find the 25th hour that everyone is looking after in his or her days. Again, thanks very much to Alessandro. Again, thanks to everyone. We learned a lot from this webinar, and also we learned that Pádraig's cup has an eye, and so probably he is the big brother out of all the panelists who's surveilling the information and the personal data of the entire world.